I often hear questions from my clients as to whether or not they're going to have to go to court if they file bankruptcy. Technically, you do go to court. There is a court hearing, and it's called the first meeting of creditors. And that's a misnomer for two reasons. Number one, there's no such thing as a second meeting of creditors. There's only one. And as a general rule, none of your creditors show up at the meeting that's called the meeting of creditors. They have an opportunity to show up if they'd like to ask you questions about your debt, but in most cases, creditors don't appear at that first meeting of creditors. Instead, the first meeting of creditors is basically a meeting between you, me, and the Chapter 7 trustee who's been assigned to your case, or the Chapter 13 trustee. That meeting will happen approximately 1 month after your bankruptcy petition gets filed with the court. And the purpose of that meeting is to give the trustee the opportunity to ask you any questions that he has about the information in your bankruptcy petition. Usually the trustees have very few questions. In other words, if the petition is prepared thoroughly and all the information is placed in the petition, then most of the trustees' questions are answered by the information in the petition. That's technically a court hearing that you go to, but it's not held in a courtroom and there's no judge present. In most cases, when somebody files bankruptcy, they never see a bankruptcy judge, although there are exceptions to that rule. In other words, if you file bankruptcy and during your bankruptcy case, you want to get court permission to sell a house or to buy a car, then that requires a court hearing, and you do appear in court at that time. But as a general rule, most people never show up in the courtroom, and the only hearing that they have is their first meeting of creditors.